and welcome to a newsflash episode of Unpacking the Case, the podcast by David Jones Bold, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. What should have been a straightforward step, getting consent for demolition, turned into a legal roadblock that risked holding up a major Manchester regeneration scheme. The High Court stepped in, and the reasoning is worth paying attention to because it goes right to the heart of how far landlords and public authorities can go when refusing consent, and when that refusal can become unlawful. In this episode, we're going to break down what happened in Great Jackson Street Estates and Manchester City Council, why the distinction between alteration and demolition mattered, and what it means if you're involved in regeneration development or managing public sector estates. Hi, Richard.
Hello, Lizzie.
Hello. We are here to talk about a High Court case it's actually from January of this year, but it was previously a lex tempore judgment. And we've now got the transcripts. And the case is called Great Jackson Street Estates Limited and Manchester City Council. And it's all about consent to alteration and demolition. Mm-hmm. So it's a bit of a familiar case because we've spoken about these two parties in the past, back in the summer of last year. So do you want to refresh our memories on the background facts?
Yeah, it was a Court of Appeal decision from May of last year that we did a podcast on at the time. And that's a different argument. So when I better refreshing memories, it's a place called Park Place, or intended to be a place called Park Place in Manchester, just to the south of the city centre. And Great Jackson Street Estates are a special purpose vehicle, sort of to go ahead with the development, owned by Wise Group. And there's got a lot of plans for residential developments there, but they plan 2 56-storey high, primarily residential blocks of flats with commercial units on the ground floor of each. And 1,037 flats. Just imagine that, Lizzie. The first case, and just to recap, it was all about restrictive covenants. There were a series of restrictive covenants which would basically prevent the development. Manchester City Council had already given planning permission for the developments, but they wanted to then argue, so that the restrictive covenants could be enforced. And Great Jackson Street went to the Upper Tribunal Lands Chamber under Section 84 of the Law of Property Act to modify the restrictive covenants. And Section 84 basically is that Section 84.12 allows you to modify restrictive user or building covenants in leases, but only if the lease was more than 40 years initially and at least 25 years of it expired. And that was the case. The leases were originally granted here in 1978. They've been extended subsequently, which will give rise to a surrender and a re-granted lease. But they were basically 99-year leases with just over 60 years left on them, so you qualify within Section 84 survival. And they wanted to argue that, the covenants of Section 84.1, the covenants primarily prevent reasonable use of land and don't secure any practical benefits of substantial advantage, or that they're obsolete, or that there was no harm to the council in discharging the covenants. To cut a long story short, you can listen to the previous podcast, but the tribunal refused to modify the covenants, and the Court of Appeal basically agreed with that. They said that the fact that you've got planning permission is quite distinct from whether the covenant should be discharged or not. And the council could see had good reasons to kind of not just physically control, but strategically control the development and ensure that it went ahead timelessly. That was the first case. So the first round was to Manchester City Council. They won it.
So what's the latest?
What also happened is they tried to obtain leave to appeal to the Supreme Court. And we're talking about a £350 million development site, so you tend to plough a lot of money into it. They were refused leave to appeal to the Supreme Court at the end of October last year. So the next stage is, can they go ahead with the development without the modified covenants? And that's what the High Court decided at the end of January. And shall I tell you?
Please do. What happened?
They they basically wanted to demolish the premises, which were two warehouses, these 1970s warehouses, which have been redundant since 2008. A bit of an eyesore by all accounts. I should have gone there when I was in Manchester on Tuesday and had a look at them. I wasn't far away. But there was a covenants, standard covenants in the leases that said there should be no additions, alterations, improvements without the consent of the landlord, not to be unreasonably withheld. And there was a user covenant not to use other than as light industrial units or warehousing without the landlord's consent, but not to be unreasonably withheld, missing on that occasion. And the landlords basically, Manchester City Council, refused consent on 10 different grounds. Shall I tell you what the grounds were?
Yes, please.
Firstly, they tried to argue that you'd be breaching the user covenants because you could only use the premises for light industry or warehousing. And that wouldn't include sort of demolition and building skyscrapers. Secondly, they said that there was an obligation to keep the premises in repair, so you should repair these redundant warehouses. I think that was a bit of a non-starter. And related to that, it's the law of waste, common law principle, that you would be committing your waste to physical damage to the property. And fourthly, they argued that demolishing wasn't the same as altering or having additions to the premises within the covenant. They also argued that Section 84 claimed that they were going to appeal at the time, but they didn't get the ability. The Supreme Court, as I mentioned, refused leave. Would be undermined in their other activities. They argued that they would keep the value of the reversion if buildings were still on it, and they also argued that all the leaseholders were trying to do Great Jackson Street was use the sort of demolishing as leverage. They also argued that they couldn't show adequate funding, they hadn't given any details of methodology, and there were no formal undertakings as to costs. So 10 different grounds. And shall I tell you what the High Court said?
Yes. What was the conclusion to all of this?
Well, they said that demolishing is altering the premises. This argument that not to demolish doesn't cover isn't covered by the alterations provisions was wrong, and there was no waste involved in demolishing the premises because you've got an alteration covenant. They also said a repairing covenant to keep the premises in repair couldn't prevent demolishing when you got a alteration covenant which allowed it subject to consent not to be unreasonably withheld. And they said also that the user covenants that you can only use for light industrial warehousing didn't mean to say that you had to. It just meant to say that you couldn't use for other purposes, so you can demolish. They said that in terms of protecting the value of the reversion by keeping buildings there, the judge had visited the site and it was a derelict wasteland anyway, which is nice to know. And so it didn't really make any difference. And if you wanted to sort of make sure the site was in some way protecting, just wasn't a gaping hole for years, you could put that in the conditions like landscaping in your license. So for all those reasons, the landlord can demolish the premises, the judge decided. We'll have to see what happens. But Manchester City Council had £80,000, the rumour is, of costs. That's what's said in the local government lawyer anyway, working against them. So, there we go. You must have good reasons for, alteration covenants include demolition. That's altering the premises in many ways. And that's it.
Excellent.
Lizzie.
Thank you very much.
Okay,
thanks, Richard.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.